guys, you're Miss CITRA AGNESYA Ginting, right? Welcome to the job interview. Please have a seat. I'm AURELIA and this is my partner, ORLIN KAULIKA. First, we'd like to thank you for your interest in our law firm.
So today, in this interview, your job is to convince us on why we should hire you. We've read your resume and I'm pretty sure you already know that we tend to hire candidates from prestigious law schools from our record to make sure that our employees have high quality. And the fact that you're not from any of them, what makes you think you're qualified for the position you're applying?
What if I told you that I am better than those graduates and I've actually passed the bar?
Well, why don't you prove it?
That's Indonesian civil code, right? Open it up, read me something.
On Article 1320 of Indonesian Civil Code, it is stated that in order to be valid, an agreement must satisfy the following four conditions. First, there must be consent of the individuals who are bound thereby. Second, there must be capacity to enter into an obligation.
There must be a specific subject matter and there must be a permitted cause.
Well, that's not enough to make you better than other graduates. Here's the book. I'm going to show you what an attorney from Diponegoro University can do. Pick any section.
I love to explore more about this topic, ma'am. Let's not change it. Section 2. Concerning the conditions that are required for the validity of agreements.
Fine. Pay attention while I'm elaborating more about the first condition. We all know that for an agreement to be considered as a valid agreement, there must be consensus from all parties involved. This implies that the agreement must be made without coercion nor pressure, but purely based on one's own will. This has also been emphasized in Article 1321 of the Civil Code, which says that no consent is valid if it is granted based on mistake or obtained by duress or fraud. Now, can you add something to the conversation?
On the second condition, in order to determine whether someone has capacity to enter into an obligation, it is also essential to understand who, in accordance with the law, is incapable of making an agreement. As stated in Article 1330, individuals who are considered incompetent to conclude agreements, namely minors, individuals under guardianship, married women in the event stipulated by law, and in general, individuals who are prohibited by law from concluding specific agreements.
I think you missed a crucial point here, Ms. Ginting. As the law has evolved, a married woman is considered capable in taking part on legal action as stipulated in the Supreme Court Circular Letter number 3 of 1963, which invalidates Article 108 and 110, in which stated that a married woman is required to ask permission from their husband in carrying out legal actions, which in this case taking part on legal agreement. So, it can be said that the third point of Article 1330 has been declared no longer valid. Now, how about you continue in elaborating the third condition and try to impress us?
Sure, the third condition regarding to the validity of an agreement is that in the making of it, there must be a specific subject matter. This means that there should be something that is being agreed upon, and that is what we call object of the agreement. The object of the agreement must be clear, and not only it can be form of the physical asset, it can also be in the form of services. And based on Article 1333 of the Civil Code, the quantity of the matter might be uncertain unless such quantity can be stipulated or determined at a later date. Now, shall I continue on the last condition?
Well, so far you've been doing pretty well. Now, for fourth condition of an agreement validity, we can clearly see that an admissible cause is required. This condition is also supported by Article 1337 of the Civil Code, which firmly stated that a cause is not permissible if it is prohibited by law or if it violates good conduct or public order. The word cause, which in this case is translated from Dutch word oorzaak, refers to the content and purpose of the agreement rather than the literal thing that caused the agreement. If this fourth condition is not met due to inadmissible cause, the agreement can be declared as a void ab initio. Can you elaborate further regarding this matter?
Absolutely. As we previously discussed regarding the fourth condition, the first and the second condition are subjective conditions, whereas the third and the fourth conditions are objective conditions. In the case when the subjective conditions are not fulfilled, the agreement is considered avoidable. This kind of agreement is identified as legitimate and enforceable, but can be rejected by one party if it's later shown to have defects. It is different when the objective condition is not fulfilled. The agreement will be considered as a void agreement, where the agreement basically never occurred and had no obligatory power over any parties, known as void ab initio.
Well, Ms. Ginting, knowing that you didn't go to any top-ranked law school, I must say that I'm quite impressed by how you understand and elaborate this specific matter, because we know that as a lawyer, understanding about the validity of an agreement is an important thing to master. In many of the cases we handle, most of it often originates with an issue in an agreement that eventually creates disputes. And in this situation, you as a lawyer must be fully prepared to assist your client in a provisional manner to make certain of all ambiguities in the agreement, because after all, the essence of an agreement is settling the interests of both parties.
I think we reached the end of our allotted time. We surely had a great time in discussing this matter with you. Next, we're going to review your resume in addition to the information that we just obtained from this interview. We'll be back in touch with you via email, and if fortunate, we're hoping to see your contribution in our law firm.
Thank you, ma'am, for your kind consideration. Thank you, ma'am.